and Erica's the Learning and Development Director at Experts Direct, a firm that provides expert witnesses for various matters, including native title. And she's speaking today, you would see in the program, on the development of the rights and interests issue. Following her, we're going to have Andrew Collett, who's a barrister with 40 years experience and who's worked extensively on Aboriginal matters. And he'll be commenting, followed by David Martin, who is well known as an anthropologist of long standing. So please welcome Erica this morning, and we'll have time for questions afterwards. Thank you.
Thank you so much. I'm very grateful to be here today. So I spearhead at Experts Direct our education initiatives for both lawyers and experts. And this year we're launching our online expert witness training program, which is designed to help both novice and experienced experts to understand their work as an expert witness and write robust expert reports that are capable of withstanding cross-examinations. And we typically connect lawyers with experts in highly niche areas, anthropology and native title claims being one of those areas. So you can see on the screen just a little bit of an outline of what I'll go through today. I will be going through the content quite quickly, but a copy of my slides and my paper will be made available to you post the event. So it might be trite to talk about what the role of the court is, but I think it's important just to go through that. So the court is a tribunal of fact. A judge will listen to the evidence adduced by the parties and then decide what evidence is relevant, including expert evidence, and what facts have been proved. They then apply the law to the relevant facts and come to their decision. And while the court is the ultimate decision maker when it comes to the rights and interests of parties in native title cases, it would be unable to do so without the assistance of expert witnesses. So before examining the role and the challenges arising from anthropological evidence in native title cases, it's important to understand what expert evidence is and the role of the expert witness generally. So generally speaking, evidence of an opinion is not admissible. But of course, like everything in law, there's an exception to this rule. And Section 79 of the Commonwealth Evidence Act provides an exception and says that opinion evidence is admissible where the person giving the evidence has specialised knowledge based on their training, study or experience, and where their opinion is wholly or substantially based on that specialised knowledge. Expert witnesses have played a vital role in the resolution of disputes and the administration of justice in common law jurisdictions for many centuries. And the role of the expert witness is to assist the lawyers in a matter and ultimately the court to understand their field of expertise, their field of specialised knowledge, and how it applies to the facts in issue. So an expert, as I said, is a person who has acquired their specialised knowledge based on training, study or experience. There's no definition in the Act of what specialised knowledge is, but it's another term for expertise. And it is a field of knowledge that is outside common knowledge, a field of knowledge that the court and lay people need your assistance to understand. And for an expert's opinion to be admissible, the opinion must be wholly or substantially based on that field of specialised knowledge. One of the points Julie had in her slides yesterday was that the number of practitioners involved as expert witnesses in land claims remains low, with no clear path to becoming an expert. I should note that there's no certification or accreditation required to become an expert witness. If you meet the threshold requirements in Section 79, that is, you possess specialised knowledge based on your training, study or experience, you don't have to have all three, you can put yourself forward to be an expert. It will then be for the lawyers to determine your suitability for a matter, and ultimately the court to determine the admissibility and weight to be given to your evidence. When presented with admissible expert evidence of any nature, the court must consider the weight to be given to the expert's opinion, the logic which underpins the opinion, the relative skill of the expert witness, and the certainty of the facts upon which the expert's opinion is based. Further, the intellectual processes of the expert must be readily exposed in their report. That is, the primary facts assumed or understood by the expert must be apparent, their reasoning transparent, and the premises on which they depend identified. Expert evidence is routinely adduced in native title cases, and the qualification of an anthropologist as an expert as a result of having acquired specialised knowledge based on training, study, or experience is rarely contested. The role of the expert in these cases is to explain how anthropology, as a field of specialised knowledge, applies to observations of the expert and the basis materials relied upon to produce their opinions. Much of the evidence which a court will need to consider in native title cases may be evidence other than from the personal observation of witnesses and might ordinarily be regarded as hearsay evidence. Hearsay evidence involves a witness giving evidence of what they have heard another person say about facts occurring outside of court. A witness who did not see or hear what occurred cannot give direct evidence about what happened. For example, a witness who gives evidence in court saying person X told me that person Y was their mother is giving hearsay evidence. And generally speaking, hearsay evidence is not admissible as it's considered unreliable. However, once again, there's an exception to this rule. And the legislative rule that permits the court to receive expert evidence does not require the facts upon which an opinion is based to be supported by admissible evidence. The fact that an expert's opinion is based in whole or in part on a fact supported by hearsay evidence is not a ground upon which the opinion must be rejected. In native title proceedings, hearsay material may be comprised of statements made by members of a claimed group living at the time of the trial and who are either not called to give evidence or who are called but give evidence not in terms of the statements contained in the reports of experts. Where the court is required to make a finding about the practice of traditional laws and customs occurring well over a century ago, it may be unable to rely on the direct personal observations of witnesses. In Mabo and the state of Queensland, at first instance in the Supreme Court, the state raised around 300 objections to the evidence given by Eddie Mabo concerning what he had been told by his grandfather about the traditional laws and customs of the Meriam people and the rights and interests he had in the subject land. And these objections were raised on the grounds of hearsay. On the question of whether the court could rely on evidence other than that based on the direct personal observation of witnesses, the judge said, "I have little difficulty in accepting that the fact of assertions being made by persons other than a witness may be relevant and hence admissible. The evidence is not, without more, however, necessarily admissible as to the truth of the matters asserted." It's accepted by the courts that there are evidentiary issues which are peculiar to native title claims. As one commentator has stated, quote, "Perhaps the greatest clash between Aboriginal and Anglo-Australian systems of knowledge is in relation to the form the knowledge takes. Oral traditions and history are usually the basis of Aboriginal connection with land and, accordingly, are of major importance to land claims and native title applications. As well as the dreamings, genealogies, general historical stories, and land use information will be transmitted orally in most Aboriginal communities. Yet the Anglo-Australian legal system is the most prohibitively literate of institutions," end quote. Hearsay material on which an expert's report is based and which qualifies for admission as relevant to the basis on which the expert holds the opinion can be used as proof of the fact intended to be asserted. The Federal Court has said that while it would not be appropriate to receive evidence of a person claiming that a third person told them something as proof of truth of fact, that evidence may be received as evidence that the third person spoke words to the person giving evidence and that person believed the third person. Indirect evidence in the form of basis materials, including genealogies, scholarly articles, and publications, may also be adduced by experts to assist the court in the determination of native title cases. The function of genealogies is not restricted to the expression of opinion by anthropologists, but also extends to genealogies as evidence of the truth of the statements contained in them. Genealogies prepared by authors employing specialised skill and understanding is an appropriate field of expert evidence and are likely to be reliable records of statements and appropriate to be admitted in native title cases. An anthropological expert can and should rely on basis materials, such as publications and scholarly articles. It would be impractical to require the expert to base their opinion only on knowledge or information that has been independently proved. However, the reliability of early anthropological and historical basis materials can be problematic because of language barriers and the difficulty in reducing information to writing at the time. In addition, historical materials and publications may have been written at a time when societal perceptions of Indigenous people and their customs and traditions were different to our contemporary understanding. As such, and quoting from a judgment, which is referenced in the paper, courts must consider whether the historical record or account of observers at the time, whether trained or untrained, is not invalidated by a particular preconception, bias, or prejudice of the author. These are all factors which an anthropological expert witness must keep in mind when formulating their opinions. Experts must also remember that the mere adoption and restatement of an opinion of another expert is not sufficient to render the evidence of the first expert as opinion evidence in accordance with the rules of evidence law. So as an expert, you can't simply restate the opinion of another expert and present that as your own expert evidence to the court. An expert who considers the opinions of other qualified people in their expert report must make it abundantly clear in the report when they are doing so. In addition, the expert must be transparent in their reasoning and clearly identify the premise on which their opinions depend. The court will decide how much weight it will give to the evidence put before it. No evidence, including expert evidence, should be artificially strained to carry more weight than it can reasonably support. In navigating legal complexities, expert witnesses play a crucial role in providing clarity and understanding of matters beyond the scope of the knowledge of the court. Anthropology is not an exact science, exact discipline like maths or science, as you know, and in native title cases where history and tradition intersect, expert anthropological evidence is particularly vital to the court. By carefully considering admissible expert evidence and determining the weight to be given to it, the court aims to achieve justice while considering diverse perspectives. Just because the evidence of an expert in proceedings is not ultimately accepted by a court, that doesn't necessarily mean that the court has not been assisted by it. And I think this goes to a point that Kevin made in his keynote speech yesterday about the importance of the preservation and digitisation of expert evidence in native title claims. The evidence as a whole, whether it is ultimately accepted by the court, should be preserved so that we have that on record because it may be of assistance at a later stage in different claims. An anthropologist engaged as an expert witness in native title claims who executes their role in accordance with their obligations to the court plays a critical role in the administration of justice for Indigenous communities. If you're interested in becoming an expert witness, I'd encourage you to register with Experts Direct. It doesn't cost anything to register as an expert. You can submit an online form and upload your CV. We then prepare a profile, and if we get an inquiry through from one of our clients, being law firms, and you're a suitable candidate for that matter, we'll put you forward on a short list. We have a number of anthropologists on our database, and we have put forward experts for consideration in native title claims. If you've acted as an expert witness or you are interested in becoming one, I'd also encourage you to register your interest for our upcoming online expert witness training course. using the QR code on the screen. This course is designed for novices and experienced experts. You can view the details about the course when you scan the QR code. The course is designed to be completed online and supported with fortnightly calls. You can go at your own pace. I have facilitated a lot of the training in relation to obligations of expert witnesses and your role to the court, your duties under the Expert Witness Code of Conduct. And my colleague, Rec Walton, who is a former barrister at the New South Wales Bar, presents the components in the course on report writing and also going to court and surviving cross-examination if you get to that stage. So with that, I will now hand over to Andrew.
Yes, unfortunately, that is me. In the 7 minutes I've been allocated, I'm just going to pick up on 2 points from what Erica has beautifully set out for you. And the first one is this point that all opinions must be totally based on facts established or accepted by the court. If your opinion ends up based on facts that aren't accepted, those facts are hearsay and your opinion will fall away. So it is really, really important that your opinion is based on established facts. And I'll go into some detail as to how you might do that. But if I can give her an example, it's the second dot point there. And that this is the actual question that an expert was asked in the Bootu Creek desecration of a sacred site question, that is, whether it was reasonably foreseeable that open cut manganese mining near a sacred site would cause damage to the site. That was the legal question that had to be answered, but the foreseeability is obviously a factual question which a mining expert had to answer. Now, why I'm telling you about this is because, unlike all of the opinions that you are likely to give in anthropological matters, there are really only 4 facts that had to be used as the basis. How far the mining operations were from the sacred site, the geology and the soil structure at that point, and the depth and the angle of mining. There's really only those 4 considerations. And it was ex post facto because the mining had happened and the sacred site had fallen in the open cut pit. But that was it. And the point I'm making is there are only really 4 facts that have to be established. The other point I want to talk about is the opinions must be independent, and these words are probably important, that the opinion must be detached, accurate, and objective. But native expert evidence and native title case, in my view, is one of the most difficult areas of expert evidence. And in my 40 years involved in Aboriginal matters, I've been involved in lots of other areas where experts have been involved: stolen children, personal injuries, and medical negligence cases. And again, generally, the number of facts that an expert needs to rely on in most of those cases is much less, except perhaps stolen children. As I point out there, in the opinions you give, often there's hundreds of facts that you have to marshal. And the other reason why I say there that I think expert evidence and native title is one of the most difficult areas is because often, perhaps inevitably, anthropologists on the claimant side have developed affiliations with the group that has commissioned the expert opinion, and not unnaturally wants the group to succeed. Just dealing with the first one, the opinion needs to be based on established or accepted facts. There's been a very difficult example of how not to do it recently in that Barossa Santos case. Most of you probably know a bit about that, but the essence of it was that traditional owners of the Tiwi Islands some only, not all, challenged the Barossa Santos pipeline on the basis that the pipeline may well interfere with crocodile man dreaming, and it may well be that it interfered with the rainbow serpent who was responsible for that area. So, as you can imagine, all the evidence about was whether there was a crocodile man sites in the vicinity of the gas pipeline, and likewise in relation with the rainbow serpent. And I'll just read you a bit in a minute about some terrible findings that had to be made by the judge. But what you need to know is firstly, when you give your opinion, you need to know what evidence is going to be called, which witnesses are going to be called, what they will say, because only then do you know what the evidence will be that you can base your opinion on. And you also need to know facts that have been agreed or not in dispute, because if they've been agreed, they're established facts. Also, of course, as I point out number 6 there, you can rely on what you've seen, for example, ceremony or avoidance behaviour, and occasionally what you've heard, for example, ritual souls or keening fuels, because that's evidence that may be relevant to your opinion. Going on to the second point, it is critical that you are and you appear to be independent, both in your contact with witnesses, in your reports, and in their evidence. And so, where I say then number 7, what to do, it's really important that you give independent, objective opinions that aren't intentionally biased towards the party that has retained you, and put that in the phrases that Judge Justice Charlesworth used in the Barossa case. You're not there to be an advocate or a barrister, and sometimes that's difficult if you're acting, if you've been involved with a native title group, you've made friendships, you want them to win. But I'll just give you a very quick example of exactly the finding you don't want from a judge. And this is in the Barossa case where a geoscientist was involved, and the finding was, in cross-examination, Dr. O'Leary admitted the words he'd used in the morning session about a previous dreaming, a kangaroo dreaming, and a map he'd shown, were not true. He said it had nothing to do with stopping a development. He said he now regretted saying the words because they are incorrect. The judge concluded, this is a startling admission. Not only is it damaging to his credit, it causes me to doubt his understanding of the obligation of an expert to remain impartial. The judge also was very critical of one of the anthropologists and the lawyers who were not from native title organisations but were from the Environmental Defenders Office, saying that they were partial, partisan, and coached the witnesses. Exactly the sort of thing that you don't want to do or to be said about you. How do you deal with this? I deal with that in the next dot point. You discuss with the lawyers who are instructing you the questions you'll be asked, in particular determine their relevance, whether they come within your area of expertise, whether they're the right questions. The lawyers may not have asked the right questions. Federal court judges encourage experts to talk to lawyers about whether the questions are relevant and appropriate. And of course, given what I've said about the importance of establishing the evidence, talk to the lawyers about the evidence that they can lead to give the facts that are relevant to your opinion. And lawyers will gladly talk to you about that. Next point. important. Sit in court and hear as much of the Aboriginal and anthropological evidence as you can. That's the best way to know what evidence is going to be established. The other points are obvious. Prepare thoroughly. And I just threw in, don't take criticism in court by the lawyers or the judge personally. They're there to do a job. You're there to do a job personally. And finally, a few things not to do. It is really important that you don't get stuck on defending your opinion against decent criticism. Do not refuse to concede obvious or sensible propositions which may be adverse to your opinion. If you do, if you're dogged and you hang on in the face of fair and reasonable criticism, the judge will say, this person is partisan, this person is a barracker, they can't concede the reasonable. And the next one is really important. Don't allow your friendship with or your obligation to kindness to colour your judgment. Also, don't show in any way during your preparation or your discussions with traditional owners or in court that you're taking sides. An example I want to give about this was a case that I was involved in the Dampier Peninsula, and the anthropologist who I was leading is a very experienced anthropologist, and he was well cross-examined by a barrister who, in the course of it, played to him some of his tape recordings of field discussions, which they'd got hold of and gone through like a fine-tooth comb. And there was just one bit in there where this anthropologist was in a car with various traditional owners, and he elicited an answer from one of the traditional owners in response to a legitimate question. But at the end of it, he said, "Great, we've got it." And that was not done. And you could have heard a pin drop. And that anthropologist lost his composure, not surprisingly, lost his concentration, and lost his mojo for the rest of the day. Now, I'd led him for about half a day in chief, and he was cross-examined for 3 days. And for one of those days, until he took that night and recovered, his evidence was below par, and he was visibly, palpably affected by it. And it won't surprise you, at the end of the case, his evidence was not preferred. That was the evidence the other anthropologists were. So it is even little points that can come back to haunt you. And the important thing is, of course you develop friendships and associations, but you have to be professional. It's not easy. And the last point I've made is never be disrespectful at any stage to the court or the legal process. And I think in the case of this anthropologist, it was easy often to say, look, to traditional owners, look, don't worry about the court. We know what's really going on here. And that came back to haunt him. So that's as much as I want to say to you at this stage.
What I want to do is to draw on some of the themes of Erica in particular, and in fact, much of what I cover is speak, although in a different way, by our legal friend there.
Sorry, Dave.
Yeah. Okay. Yeah, I'm not used to shouting people. I beg your pardon. So first, I want to talk about the position that, to use a graphic way of representing the difference between what we do when we're experts as opposed to what we do as anthropologists. Typically, if we're writing especially academic anthropological articles, we base often a complex exegesis based on particular theoretical paradigm and so on and so forth. And the actual, what the lawyers might think of as evidentiary basis might be a small matter. The triangle is reversed to this one. The facts and opinions are less important than the exegesis and the points that it's making. However, the facts relied upon and the way, in fact, the law calls these complex information we receive in fieldwork, for example, are seen as facts, the basis on which we rely One of the points that I want to make here, which I think is foundational, and it's been alluded to, is the process of reasoning. It's not just that the opinion needs to be based on those facts, but the process of reasoning needs to be specifically and demonstrably anthropological. And I think it's often in the absent when, for example, reports I've assessed either for the state or indeed for a review for a rep body, often there will be 4 or 5 pages of complex discussion of particular phenomenon, and then a line based on the foregoing. It is my opinion that blah 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 blah. That's completely useless to an anthropologist. Sorry, to a lawyer. Completely useless to the court. Typically, they require each opinion to be based on an identified and clarified statement. So that's one difference between what we do as anthropologists in the academy or more general writing and so forth. Now, I want to talk about things that I think bear very directly on our roles as anthropologists, and that is to go back to the foundational principles set by Mabo. What is this thing, native title? What is this bundle of rights? And this may seem trite, and we know this. People have been saying it for years, but it actually has a profound impact on how we write, or how we should write in our reports, in my view. Firstly, the native title is a title that's recognised by our legal system, and at least as I see it as an anthropologist, it's very much concerned with our property law system, in which property is understood as a bundle of rights and interests. So whatever that complex world is, that connections under the laws and customs to the lands and waters claimed, as the Act puts it, those connections are translated into rights and interests. The native title, the right to do this, the right to do that, and so forth. So remembering then that this is not just a recognition space, that this is the space in which Australian law recognises, and as I was saying, it's very much concerned with the impact of the laws and customs and the rights and interests on the rights and interests that others. So you could see this very clearly in pastoral lease ones, where the rights of the pastoralists and the rights of Aboriginal people, their native title holders, overlay each other, and there's a hierarchy. So the fact that these are translation spaces as well as recognition spaces is really important to how we do our work, because this notion, the Act itself doesn't specify what the translation is, when we're talking about connections, again, a highly useful word, the connections to the lands and waters. It is not an open slather, impetus for us to write about the system, the culture of that group. It is to focus on those connections which bear directly on the matters which are a concern to the legal system. That is, how does it impact on our property law system, the rights and interests? Now, if we take that approach to what we're doing, then it seems to me that there's a whole set of entailments that come up from that, from the fact that we understand that our role is part of this translation space, of defining this translation space. It is our role to set out, as I see it, what those connections to the lands and waters claimed are, in terms that we as anthropologists use, with the understandings that we as anthropologists understand, based on research, our own research, but also on the literature, on the history of development of ideas about Indigenous tenure systems and so forth. That's our job. It's a job of translating into a form cognizable to, incapable of being incorporated into the property law system in Australia. Now, if you take that perspective, and it seems to me, and I'm open to debate, that this is this is the logic of this thing called native title that's been created through Mabo, then it seems to me that there's a whole set of matters that we need to think carefully around what I've seen a lot of in native title practice in terms of reviewing reports and so forth. And that is, unwittingly, we are being dragged into giving opinions on legal matters. For example, if one accepts that rights and interests are a translation of a system of connections, what I call connections of a possessory nature, if we accept that, then we, and this is up for debate, it's a view that's shared by a number of lawyers. It's been published by Robert Blowers, senior barrister, that the rights and interests essentially is a question for the lawyers. It's for us to set out the matters which relate to, which could be translated into the equivalent of owning country or various other rights and interests, the entailments that come with owning country. So if you follow that, then what we should be focusing on, which I think is good anthropology, not say listing the rights and interests that the group we're dealing with will hold if they're successful, but rather setting out the nature of the connections which bear on the purpose of the native title system. That is, connections to country which impact on other landholders or can be incorporated into the Australian property law system. So that's the first one. And I have found it myself in two of the reports that I've been with colleagues writing, to be able to focus on what those connections are without trying to answer the lawyer's questions about what interests, rights and interests do they hold, is actually liberating. It means you can write you can be a good anthropologist and talk about this complex world of possessory connections. And then I don't see anything wrong with then sitting down with the lawyers and saying, well, these might be the things, but it's essentially the legal task to turn that into what can be cognizable to the law, to be converted into, translated into. And there's a whole set of others that I think we should resist giving answers to. Society, this is an enormously vexed question. We have now jurisprudence, we're thinking of Drury, where the judge has said the language group is the society. But we as anthropologists know that certainly in the classic systems, and you can see it in today's worlds too, that although people now talk about boundaries, that in the past, the sovereignty, or as well as we can deal with that from the available information, that there weren't these cadastral-like boundaries, that the fact of a particular language being in a particular place is not because that's a language community, like the Scots and the English and the Irish, whatever, or in northern Italy, the Italian and the German speakers, etc. It's not a language community. It is a language that is understood as having been emplaced by the same creator heroes that left law, society, culture, etc., etc. It's a foundationally religious system, or they were foundationally religious systems. And so by focusing, by answering a question, is this the relevant society? We're failing in our duty to give an answer. As an anthropologist, we're being asked to formulate our views of what is a jurisprudential, at the best, construct. And there are so many ways of managing that in so that one can't. But I would draw, though most of you won't have had anything to do with Cape York matters at all. But in Cape York, and I'm trying to grapple with Lauriston Sharp, when he wrote in the 1920s about Cape York, he said quite explicitly of the people he was working with in southwest Cape York, there is no such thing, his exact words, there is no such thing in Cape York as a society. If you look at whatever phenomenon you are looking at, it might be presence or absence of moieties, presence or absence of sections. There's a whole set of ritual cults. There is not they do not overlap each other. There is complex networks, he said. Now, it's if one is not, there we go, you got a nice picture. So in that case, you're not to answer the question, which I've seen people do, this is the such and such is the relevant society, is to do poor anthropology that paradoxically we're being asked by lawyers who, as we've heard, would get very scratchy when we intervene into their system. But we're being asked to give views on what is a legal construct. We should resist it. And there's a whole set of others I've listed before the same, and I'll leave it at that. But I think by understanding this as a translation as well as a recognition space, and then working through the entailments of that, we can get back to doing good anthropology that is nonetheless written so that it's accessible to the lawyers, but is not taking on board a whole lot of jurisprudential stuff, which means we are not accurately representing the situation, at least as it was. Thanks.
Well, thank you to our speakers. We have probably just a few minutes. If there's any questions, I'll run the microphone out if anyone has a question.
Sam with McCrum's solicitor's office. As a lawyer who sometimes writes letters to anthropology classes to answer questions, I wonder, and I hear what you say about the reluctance to answer the society question. I wonder whether you think it's more comfortable areas to be asked about what is the land holding unit, what was and what is now, that kind of thing.
I think there's no problem in doing that kind of question, because there's not jurisprudence which says such and such is the standard landholding unit. I think that's exactly, again, where good anthropology, which looks at what the record suggests and what older people say was the past, and then what it is today. I mean, the transition from, in areas where this is relevant, much of Cape York and well beyond, the transition from clans, patriarch clans, to families, and parallel with the move from estates to runs, is something that we can answer without falling into the trap of giving legal answers. That is at the core of anthropological understandings of tenure system. And again, underneath all of that is to write into our record, into our accounts, that these are still are to extent, profoundly religious systems, that the clan is not, as jurisprudence and as the Mabo decision said, not Mabo, but other decisions, linked by descent. Biological descent was not a feature that I'm aware of in any group, certainly not in any of the ones I've worked with. It's a spiritual connection via the patriline to the ancestral being, the totemic being. And if one adopts that, then one can move away from talking about cognatic descent as opposed to serial patrifilial descent, or whatever it is, to see how today's world often you do have connections, but they're not to be described as cognatic descent, which is a technical term, but as connections to a forebear by either or both males or females, and that ultimately lead one to connection to the old people who are in that land, and which you will join when you die. I've had young people telling me that. So it's not something that just old people do. So that kind of question, I think, is much less of an issue.
So I completely agree with your answer, but to translate it into a direct response to the question is, there's no such thing as the land holding group out of any context.
No. I mean, this again is where if if one talks about connections of a possessory nature about a given area, and then it'd be a question of establishing, well, who are the people who have connections and what kind of connections are they? There will be a range.
That wasn't the question. The question is, what is the landholding group? At what scale is one interpretation of the answer that might be anticipated? And you're saying,
You mean in a given case?
well, no, it's the answer to the question that asked. What is the landholding group? That was the question.
Under my framing, frame the inquiry in terms of what was the residual rights at the one culture in this area.
So I guess what I'm getting at is there's a lot of presuppositions behind the question, and you're avoiding those presuppositions by saying this is what I understand the connections are, but not giving a direct answer to the question in the terms of the categories in which the question is asked.
I'm not sure exactly where I'm with you. One of the things, though, is that one can't, and the problem with many of the claims one has to deal with today is they're artificially carved out. And that one of my responses to, I think what you're getting at is to make it quite clear that one can't talk about what's happening in this particular claim area without seeing it as part of a wider system in which that is a part. They're often run as being independent, quite completely different. The boundary around the claim is the boundary of that society. And we've had the Drury decision where you had two overlapping groups and they were said to be two different societies with different laws and customs. And I fail to see how any system could have two separate systems of law and custom that has its origins in sovereignty, which is required by the native to prove native title. So if what you're saying is that one embeds one's account in an account of the wider system, absolutely.
Well, that's not what I was saying. What I was getting at is the misrecognition space when the question you answer. But
Well, then that's another thing.
David, I thought would it be helpful to rather than use these terms like the society such and such to sort of speak to the northern, eastern, western, southerly connections that the area that you're briefed to understand have. So you could say, well, we understand from the ethno-historical record that the people within this region more broadly were initiating, were taking part in an initiation ceremony with these people to the west, or they were intermarrying with these people to the southwest, or, because then you're not actually focusing yourself in like delineating a society about it, but you are formed to where the kind of Venn diagram, that all the different circles may interact.
So that's exactly what Lauriston Sharp did. And importantly, he was an American anthropologist and didn't come from the British functionalist school. And so he was the one who explicitly talked about how links of various kind of ritual links and so forth were not coterminous with land tenure systems, whether or not and also whether there were sections, subsections, or not subsections there, but sections or moieties, as there are in many parts of the Cape, and so forth. So it is important to embed it in a wider one. And I think that one of the reasons for that is to assist the lawyers and the court in coming to the view that this is not something that's carved out of something an area we need to take no account of, that inevitably there are connections. There were connections in the past, and there still are connections of various kinds.